and has published articles on the criminal justice system in Nigeria. Cordelia Eke has had several leadership positions in the legal profession, including being the first female secretary of the NBA Port Harcourt branch, Secretary Electoral Committee of the Nigerian Bar Association, MBAC 2022, Secretary MB Electoral Reform Committee 2022, Member National Executive Committee NEC MBA, Chairman Law Officers Association of Nigeria Alone, Rivers State Branch, Member Advisory Committee of the MBA Port Harcourt branch, amongst others. She was pioneer and editor-in-chief of the MBA section on Business Law magazine, Business Law News, editor-in-chief of the MBA Port Harcourt Bar News, and Aula Rivers State publication, Widows' Rights in Nigeria. Board of parents in the academia, Cordelia Eke's love for imparting knowledge led to mentoring young lawyers and law students over the years. Her passion for women and children's rights advocacy led her to be appointed secretary of the African Bar Association AFBA Women's Forum. Pioneer coordinator of Rivers State branch of the African Women Lawyers Association, ALA, Nigeria, and currently South Sudan coordinator of ALA, Nigeria. Ms. Eke is an ICMC certified mediation trainer, a fellow of the Institute of Chartered Mediators and Conciliators, ICMC, Nigeria, and an associate of the Chartered Institute of Arbitrators and Conciliators, Nigeria branch. I just want to make, before yielding to Mrs. Eke, I just want to make the point that anybody who has questions, please put them in the Q&A box, and please take note that the lecture slides will be shared later on, so no need to ask questions about them. So I will now yield the floor to Mrs. Cordelia Eke. Cordelia, you have the floor. Thank you.
Tabenda, the chairman of the board of the NBA-ICLE, for that wonderful introduction. And let me welcome all those that are joining us this afternoon. Thank you very much for making time out of your Saturday to be here. It's really not easy to leave your Saturday relaxation, especially for the lawyers, to be at a training at a time like this. So I welcome everybody, and I thank you for taking time out to be part of this session. Okay, well, I've been asked to speak on case theory and trial plan. Well, it sounds like, we're going to the classroom, doesn't it? However, we'll try as much as possible not to make it look like a classroom topic. So we will start asking ourselves, what theory are we going to be talking about? What really is case theory all about? Now, I would want to say first that in talking about the theory of a case, or a theory generally, it just gives us the feeling that we're going, to talk about jurisprudence and all that. But then this is not quite jurisprudence. And I must say that if a lawyer does not consider the theory of his case, the chances are that he is not going to be able to get a good grasp of the case itself. Because in truth, what is practice without theory? Now, the difference between lawyers, between success and loss of a case sometimes is the beginning, the planning of that case. Now, if you do not plan your case well, it means you're already planning to fail. So a case is won or lost, not in the courtroom, but from your chambers, from the time you take a brief from your client and you start preparing to go to court. that is when your case is won or lost. So this is the aspect that the training is going to talk about today. What exactly do you do before going to court? That is what the case theory, trial plan, and strategy is all about. So that is what we're going to look at it. Now, what is your case theory? We'll start with that. Now, a case theory, so to speak, I don't know, do I have the slides? Do I have the slides? Can I have?
You do. Yes, you do.
Yes, okay, let's just take a minute so we just get that sorted.
No, the slides are up. We can see the slides. Okay.
Okay, beautiful. I think maybe it's from my end that I'm just having a bit of, sorry. Minimize. Okay, sorry. Now, what is a case theory about? Case theory is more or less the theme of your case. What is the story you intend to portray in your case? Sorry, just a minute. I think I seem to have lost. Mute, please. Okay, thank you very much. And I apologize for that interference. We had slight technical issues that I had to try and sort out. Yes, how do I navigate this? Okay, thank you. All right, let's start again. I apologize. Now, what is a case theory all about? The theory is basically the reasoning behind your case. What is the reasoning behind your case? Now, theory is often underestimated by practicing lawyers. It is even scoffed at, as an exercise meant for the classroom. However, the person that subscribes to that view would really be making a huge mistake. And I've already asked, what is practice really without the theory? So a theory is your theme, is your plan. It is what the picture you want to project about the case. It is also known as the theory of the case. So what is your story? When you hear the facts, when you hear your client has to give you, what is your story? So you look at the side, you can see that it comprises a summation of the facts of the case, the legal provisions and everything that has to do with that case. What is the story that you want to pass on? So the way you pass on your story is the way the court is going to look at it. And it might mean the difference between success and failure. Now, a case theory must be plausible. It must be plausible, and it must be good enough it must be believable. You have to believe it, first of all. You can't pass on a theory that you don't believe. So you have to believe what you're saying, and you have to be able to pass it on to the court. Now, in a criminal case, for example, the case theory is part of what the prosecution decides he wants the court to know about the case. So what is your story when you are talking about the case theory? Now, an effective case theory should be presented in a persuasive manner, and it is trying to urge the court to take sides with you. It must be plausible. It must be probable. It's not something you should just pluck out of the air. You want to sell a story and they tell you that, no, what you're trying to sell to us will not fly. It should be simple, uncomplicated. You have to be sure that you believe what you're saying. So they don't ask you, this thing you're even talking about, are you sure it's true? Is it correct? Is it possible? Your theory should be relatable. It should have keywords and phrases that the judge or the magistrate can relate to it. Then at the end of the day, well, first, it has to go through your case. From your first witness, this is the story you want to give to the court. So from the first witness to the next witness, everything you do has to be in line with your case theory. Now, case theory has also been defined as something, a theory that should be understandable, persuasive, comprehensive, and compelling, and should motivate the judge to decide a case favorably. So I put an example there. That is the case of Vivian Odogo and State, to show that the court actually was able to grasp the theory presented by both the prosecution and the defense. Now, the Supreme Court, in that case, overturned the decision of the Court of Appeal. Now, it's the conviction by the trial court for murder, affirmed by the Supreme Court, affirmed by the Court of Appeal, that it was now overturned, set aside by the Supreme Court. And this is what the court said. I recall I was in that case at a point, and with the Director of Public Prosecutions, I know he presented an opening statement which contained the case theory from the beginning of the case. Now, the Supreme Court, to show that it understood the theory, summed up, that particular case and said, the prosecution's theory is that out of frustration at being dumped by the deceased to whom she was engaged, the appellant managed to sneak into the deceased's apartment with a spare key, waited for the deceased, who was at work, took him by surprise when he returned in the night, attacked and killed him with a stabilizer and 2 knives. So that is a story, that's a case theory of prosecution, and that is what they want the court to believe. So all they're going to be doing in the case is projecting this particular theory. This is actually a case where a law student, was charged with the murder of a law lecturer who she was dating at the time she was in school. Now, for the defense, the court said, on the other hand, the appellant claimed that the deceased came to her at her institution, brought her to his home for a reconciliation. The deceased attacked her in the house. The deceased locked her in the house and went to work. Deceased came back. By 10 p.m., she was angry at being kept in the house when she had some assignment to do in school. Now, the deceased apologized, gave her 10,000 naira for her needs, and as the deceased was driving her back to school, 2 marksmen invaded the house and killed the deceased. So that is a story that was presented by the defense. And the Court of Appeal, the Supreme Court, you can see, clearly had an idea of what we're presenting. So it now took its decision. Of course, the considered arguments and the witnesses and all that, and eventually overturned the case. I may just add that it was basically overturned because of a pair of boots, partly because of a pair of boots that were unexplained, meaning that somebody else was in the house that evening. But we won't go to the details of that particular one. So I think we should just go straight to the significance of the case theory. So really, what is the significance? Now, commencing a criminal trial without getting the theory, of course, is like someone just getting into the car and driving without destination. You get to the courtroom, you don't know what you want to project. You don't know what you want to talk about. You don't know what the whole evidence is geared towards. So you could just ask any question you like, and whether it is it aids your case or it doesn't aid your case. That is why it's important to have a case theory before you go. So also, the case theory helps the lawyer, the counsel, to have clarity of thought and focus in addressing issues. You know some questions not to ask, and you know the ones to ask. It's because you have already formulated your case theory. It helps the counsel anticipate problems that may occur and prepare for them. It also gives the court a bird's eye view. Okay, this is what we are going to be talking about in this case. This is what we're going to try. All right, then that's fine. So it gives the court a bird's eye view of the case. And the court will know whether, oh, this is going to be a lengthy trial or it will be a very short trial, just from, having listening to the case theory that is part of the opening statement. We'll come to the opening statement later. So the case theory also provides a basis to strategize. Okay, so this is the story I want to sell to the court. Now, how do I get the court to buy the story? That will be the next thing. But already you know what you want to send to the court. That's the important thing about having a case theory. Okay, now when selecting a case theory, there are points to note. You have to remember, look at the charge. What really is the charge against the defendant? So that your case theory is going to encapsulate the elements of that charge. The story you want to sell has to have something to do with the charge, elements of the charge, significant issues you need to highlight, and you have to tailor your theory to represent those particular issues. So yes, the case theory is something you formulate privately, but then there's no direct way to get that theory across except through the vehicle of the opening statement. So now opening statement seems like a strange thing, in our jurisprudence, our practice here, but it's not quite so. The opening statement, you rarely hear it mentioned in criminal litigation when we practice in court, but then it is a vehicle through which you convey your opening statement. It is usually practiced more in the UK, Europe and America. When you watch some of these trial programs, you see that, oh, the prosecution, yes, my lord, the opening statement. And it's usually in crimes where you have the jury system. We don't have the jury system. So in such crimes, they want to impress the jury, not with the law, but with the facts, with a general idea of what the prosecution or each party wants to present. So there is no direct provision in the Administration of Criminal Justice Act concerning concerning opening statements or mentioning it by name. However, we believe it is also captured in Section 300 and Section 301 of the Administration of Criminal Justice Act 2015. Now, Section 301 says that after a plea of not guilt has been taken or no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he expects to prove the guilt of the defendant. So the fact that the prosecution is given an opportunity to address the court before he calls his witnesses, that particular point is the opening statement. That address is what we call the opening statement. Now, likewise, for the defense, Section 301 provides that after the case of the prosecution is concluded, the defendant or legal practitioner representing him, if any, is entitled to address the court to present his case and to adduce evidence where so required. So now, while in the case of the prosecution, because it starts at the beginning of the case, for the defendants, you will notice that it says only upon conclusion of the case of the prosecution. That's when you're called upon to open your defense, then the defendant is allowed to address the court to make an opening statement. So the opening statement, of course, must contain the case theory. It should be presented in open court. It's expected to be brief and succinct, presented, as I already said, just before either party calls witnesses. Those are the main things to note. Now, some states have taken a step further to issue practice directions with respect to the opening statement, clearly identifying the need for an opening statement. Now, an example is the Rivers State Criminal Trials Practice Direction number 1 of 2023. Now, Section 3A, sub 2, provides that an information or a charge, it provides for an information or charge to be filed by the prosecution, and it must be accompanied, amongst other items, by an opening statement containing issues for trial. Now here, the Rivers State Judiciary is providing for the opening statement to be filed alongside the information or charge. Okay, now Section 3B of that section says, 3B1 provides for the defendants, upon being served with information or charge, to file an opening statement containing issues for defense. Now, if you see this in, and you compare with the provisions of the ACJA, it would appear to be somewhat contradictory to the provisions of Section 300 and 301. Now, first, the practice direction is asking, or is directing, that the opening statement be filed. What some persons believe is that the opening statement should be oral. It's part of advocacy. It should be delivered in court, not adopted as a written address, unless, of course, there's room for adumberation. So that's one of the critiques there. Then, now the practice direction is also talking about the defendant filing his own at the beginning of the case. If he's filing it when he's being served, or after he has been served with that of the prosecution, it means that he will not be given that opening statement when he's opening his own defense, unless, of course, he files it and still waits till he opens his defense to argue it in court. So, there's a slight disagreement in that area, among some lawyers. So, well, why really don't we use opening statements? Your guess is as good as mine. But I've been in courts where the courts decided that it's a waste of time. Counsel, we have so much to do, congested cause lists. It's a waste of time. Why don't you just go straight to the meat of the matter and call your witnesses? Some lawyers also look at it as a waste of time. Let's just go straight to the case. That's why most times we do not have the opening statement being given its pride of place in proceedings. But I dare say that it's really a huge loss to us. And I think it's time we start looking back at the benefits of the opening statement so that we can adequately utilize it. Now, let's say opening statement, let's just formulate one. In the case of fraud by an accountant in a company, what will the opening statement be like? Now, let's say for the prosecution. And you have to Oh, sorry, I mistakenly muted. Now, for the prosecution, you could say something like, my lord, before this court is a case of betrayal of trust reposed by an employer on his employee. The prosecution will show by direct, circumstantial, documentary, and expert
Something wrong with your audio, you're frozen.
growing his personal account with
We lost you for a while, you were
sums
frozen.
of money.
Cordelia, you were frozen for a while.
Oh, okay. Sorry.
I just have to track
see.
back a bit.
Okay, now let me just do a recap. Now,
Okay.
We're talking about the prosecution. What would his opening statement be like? What could it be like? Of course, this is a hypothetical situation. A hypothetical situation. Now, in a case of fraud by an accountant in a company, what would the statement be like? My lord, the case before this court is one of betrayal of trust reposed by an employer on his employee. The prosecution will show by direct, circumstantial, documentary, and expert evidence how the defendant, a well-paid senior accountant with welfare benefits, entrusted with the safekeeping of his employer's funds, removed large sums of money. He feigned ignorance of the shortfalls, deprived the company of operational funds while growing its personal account. But for an external auditor engaged without notice, the shortfalls would not have been discovered or would have remained a mystery. My lord, if a company cannot trust its accountant, who then can it trust? To establish this fact, my lord, the prosecution will be calling a total of 5 witnesses to prove this. And we believe that at the end of it all, this honorable court will see reason to convict the defendant and give the victim the justice it deserves. So, well, that is just for instance. Of course, you can tweak it whichever way, but that statement has all the information you need about the case. The witnesses, number of witnesses, what you're trying to prove, and you're painting a picture of betrayal by an employee. So, well, the defense could decide to come up with something like this and say, my lord, standing trial before this honorable courts is a hardworking father of 4 young children who has served the company diligently for 20 years without a dent in his career. Today, he's accused of stealing the funds of the same company to which he has been loyal these many years, an allegation he has repeatedly denied. We are aware that the prosecution will employ different gimmicks to try to convince this court that the defendant committed the offense. But the defendant looks up to this honorable court to do justice in this matter, to see through all the technicalities and do justice by setting the defendants free. May it not be said, my lord, that hard work no longer pays in our country. So may it please the court. Now, of course, these are hypothetical situations, but basically, this is an idea of what the opening statement could well be like. So if you're able to present your case very well at the beginning of your case, you can pick the interest of the judge. Okay, we want to hear more, we want to know more, and that way it sets the ball rolling. So that's it about the opening statement and the trial plan. And the case theory. So let's go quickly to the trial plan. I can see that our time is also running. So now, what is the trial plan? The opening statement, of course, is part of the trial plan. You have the case theory first. Case theory subsumed in the opening statement. Now, the opening statement is part of your plan for that trial. So yes, what is a trial plan? A trial plan is more or less the method in which a party seeks to present his or her case to achieve the desired result. Of course, you all want to win. Yes, you have your case theory, you have everything. So how do you intend to win? How do you intend to have this case theory established for them to buy it? So the trial plan is like a map. I want to get to this destination. I know the destination because I have my trial plan, because I have my map, I have my case theory. So how do I get there? How do I get there? If you don't have your trial plan, it means really you do not know what you want to do. You don't know how to get to the destination. Internet's unstable. Okay, sorry. Now, a trial plan can be subject to change when new situations arise that may warrant such changes. For example, you may just find out that you were not told the whole truth by your client. You were not told the whole truth, or something happened, and then look, quickly, I have to change. You have to change here. That means, or that, like if you're going on the road, oh, a trailer fell here, so you have to go around and then look for another way to still get to that destination. Okay, so what are the components of a trial plan? A trial plan, of course, you have a case theory, facts in support of the case theory, the nature of and list of evidence in support of the facts, the applicable laws in the case and authorities in support of your case theory, the facts and evidence, the nature of evidence required to support your case, and how to secure evidence in court. Now let's just break it down. For example, look, I want to prove that this person is guilty of this crime or this offense. So how do I get there? How many witnesses do I need to call? Of course, you don't need a host of witnesses. Do I need to call 10? Do I need to call 5? Or can one witness alone establish it? The court can, for the prosecution, the court can convict if on the trial, on the evidence of one credible witness. The court can also convict based on a confessional statement alone, so long as it meets with the requirements of the law. So is it sufficient? Do I need corroboration? If it has to do with an offense against a child, the child is a victim, what does the law provide? There are some instances, maybe rape, defilement, some sexual offenses that the law provides. The court can't convict on the uncorroborated witness of just one person, of the child. So you need to know what the law says, and you need to prepare for it accordingly. So now, these witnesses I'm going to call, what are they going to establish? What part of the elements of the offense going to be established by the witnesses? We need to get what parts of the offenses will be established, what elements. So Mr. A, what exactly is his testimony geared towards? What is he going to say? So when you're examining him, you know the information you want to elicit. You don't just let him go to town telling stories. You have to know the information you want to get from him and drive straight to the point. So some witnesses can destroy your case. So it's not because somebody made a statement or so going to police that you call him or her as a witness. In fact, we had a matter where a lady we felt was going to be a very good witness. It got to a point, she kept complaining. It was a case of child trafficking. Now the complainant, will I call her the complainant? Two little children were trafficked from Rivers State to another state, that's Abia State. One of the children was discovered some time later in Port Harcourt. Two children, one was at 3 years, then the other one 18 months, were taken out of Port Harcourt. So as God would have it, after about a year, someone came to the father of these children and said, I saw a child that looks like your son. I saw him in school. I saw him, in the university. Said, I wouldn't mention the school. I saw him there with a lady. The father said, really? So they planned 5 a.m. sometime. They went to lay in wait. And yours truly, there was a son with another lady. Thankfully, the little boy saw him, recognized him, hugged him, called him. Now there was an issue. Okay, of course, the matter went to court. We needed someone to come and testify, the lady to come and testify. But you see, there were complaints here, there. And at the end of the day, it was now up to the prosecution to decide, do we really need to field this witness? Is it going to help our case? Will it be counterproductive? Can we do without this witness? So that is just one instance. So it is not every witness or everybody you have listed that you must call. That is why you need to check the witness and the relevance of the evidence in any way. What documents need to be tendered? And if so, does it need certification? Is it a public document? You need to check all that. That's part of your trial plan. Now, then what witnesses are going to tender this? You need to call an expert, you call a medical doctor, make all the arrangements. What likely objections are going to arise? Then you prepare for it. What are the trial aids you need? Do you have electronic evidence? Do you have to get a screen? What is it you need? So these are all part of what you have in your trial plan. Now, planning a case should commence as early as possible. I've said that already, because the process of planning is as important as the presentation of the case in court. Now, imagine when you are ready for your case, when you have prepared your case, you are not afraid of anybody, especially the young lawyers. I dare say, the young lawyer that has prepared and is going to face one silk, face a senior advocate like some I know, I don't want to mention their names. Ordinarily, you'll be scared. But once you are prepared, the case of David and Goliath, you are ready, you know your onions, you have confidence. And the silk comes. Okay, I know these things, and is it not what we're doing over the years? I mean, no disrespect. But sometimes the fact that you prepared makes all the difference. So it minimizes surprises in the case, and it also speeds up trial. It builds up the confidence of the lawyer because you already have steps. You know exactly what you want to do in the case. So some things you need to remember. Now for the prosecution, what are the things you need to look out for when you're planning your case, your trial plan? Always remember the burden of proof is beyond reasonable doubt and is on you. So you can't afford to make mistakes. You have to be thorough. You have to check and recheck your documents. Check the charge, check the information, and check it again. If possible, ask for a second opinion. You must make sure you're not leaving any loopholes. Follow your guts also. Don't be careless. Don't be lazy. Chances are that thing you're glossing over is what is going to be your undoing. So evaluate the case file, your witnesses. Look for your IPO. Is the IPO still available? Has it been transferred? Is there any other person in his team you need to call? In fact, you usually advise list all the IPOs, all those in the team, in your proof of evidence. In case one is not there, quickly call another person. They may be out of station. So those are things that prosecutor should look out for. So examine the charge. Somebody else may have filed it. Does it comply with the rules? Is everything provided? So cross-check the information, the errors, the exhibits, match the evidence with the exhibits, and be sure that, match the exhibits with the ingredients of the case and the facts. You will know the strengths and weaknesses of your case when you are planning. Oh, this evidence, this one is hearsay. It won't help me. I need to get some other evidence to strengthen this one. That is part of what the prosecution needs to do. So ensure that all material witnesses and everything is available. Consider filing a motion for amendment early enough if you see that there's a problem and draw up your questions. Now that's very important. Don't wait to get to court. Some lawyers do that. You just get to court and, okay, from what the person says, you start throwing questions. Yes, you're used to this, what next? No, you must prepare your questions tailored to achieve the particular purpose you want, tailored to draw out the answers. Now, what I do personally, I prepare the questions and the likely answers, the answers I want. So when I'm preparing my witness in the office, this is a question, this is where I'm going to. So the witness and I are on the same page. And you have to be careful not to just throw a surprise question at your witness in court. When you are not sure of the answer, you will be embarrassed. It has happened to me before. So you need to prepare, rehearse the questions and the answers with your, I'm not saying you should tutor him on what to say, but based on the story already told, be on the same page with your witness. And of course, you can explore alternative charges. This charge, will it fly? It may not fly. I'm not sure. Do I have enough evidence? So let's just add a lesser charge. So in case this one does not go, the other one will go. That's part of what the prosecution should do. So of course, you always be the devil's advocate. Try and get into the mind of defense. You already have the statements of the defendant in the file. What will he say? What are the likely things that will come up, and prepare for them. Now, for the defense, the defendant should prepare for trial. Maybe might not be as much as the prosecution, because he does not have a burden of proof. But then the defendant has to remember too, he needs to get somebody out of perhaps out of jail, or make sure somebody doesn't go to jail. So you cannot afford to be indolent as a defense counsel. So you have to be very critical of what the prosecution is presenting. That is why the courts, the law makes provision for the prosecution to serve you all processes before the trial to enable you prepare your defense. So the main work of the defendant or defense counsel is to look for how to create reasonable doubt. That is the bottom line. Either defend it well or to create reasonable doubt. If you're able to create reasonable doubt, then you're sure that you've gotten your client off the hook. That's all the court needs to discharge the client. Now, I seem to have gone way beyond the case theory. I don't know if we still have somebody operating our slide. We've gone way beyond case theory. So if they can just try and go to the trial plan so the people can also follow on. We're on trial planning considerations for the defense, so we can be together. Thank you very much. So let me just go on because of the time. Let's just keep going. Keep at it. Now, the defendant has to look for ways to create reasonable doubt, to discredit the witness of the prosecution, and look for contradictions in the case of the prosecution. So you examine the proof of evidence and whatever documents given to you. Now, if you were served with the pathologist report, for example, you look at it. Is this possible? Is this probable? Do you need to get your own experts, your own medical experts, to counter what the prosecution's expert is saying? So those are things that you have to do and plan ahead of time. Of course, you examine the charge sheet and the charges and look for any possible issues to raise there. And then just basically look for chinks in the armor of the prosecution and prepare to expand them so the armor falls. Then you have your way. So draw up your questions. That is also important. Rehearse with your clients and decide who should be fielded, who should not be fielded. Then, of course, play the devil's advocate. So now we're going to strategy. This is the last part of the presentation. We're going to strategy. So what is your strategy? A trial strategy or case strategy is the overall plan, the grand plan designed by a particular party to win the case. So there are plans for different stages. Oh, during examination of witness, this is what I'll do. During cross-examination, this is what I'll do. There are little plans, but the grand plan of it all, that will now be your trial strategy. How do I do this? So it's like the tactics you want to employ, in winning your case. Now, how do I apply? How do I use the materials I have? How do I use these witnesses? So the trial strategy of a counsel can actually make the difference in a case. Now, there's one of the cases we had sometime. A witness was, in fact, I was upset with my witness because he was talking about a very serious thing. I think his child had been killed or so, something had happened. And he was at the witness box, smiling away. This man, you ought to be sober. How will the judge take you seriously? You ought to be sober. They need to feel sorry for you. Later, he told me, he said, Madam, that's why they smile. I guess smiling face anyhow. I said, no, it's not anyhow. They are looking at you already. They're forming an impression. And it might well be, they may just say, are you sure this man's story is true? So it's part of a strategy, and it's a strategy to some extent that you need to communicate your client so you are on the same page. So now, what image you want to present of your client, of the case before the judge? How do you want to present it? That's a strategy. So that strategy goes through the entire proceedings. But of course, if you need to change strategy, yes, please, you can do that. So it is important when you're planning your strategy to know the judge. Knowing your judge is important, very important. Because if you don't know the psychology of a judge, you may just have problems. That your strategy may not work. That's the truth. Your strategy may not work because the judge will just look at you and he's not moved by what you're doing. So you need to have an idea of what kind of person this judge is. Is he malleable? Is he somebody that will listen to this kind of case, with this kind of story? How does he see? Will he feel sorry for my witness or not? So you need to know your judge. Know his disposition to criminal cases before ascending the bench. Now, was he a defense attorney? Was he a prosecuting attorney? Was he a law officer? Chances are that if a judge or magistrate was a former DPP or a prosecutor, he might just be more inclined to convict. That is, so you have to know where the judge is coming from. Who is he? Now, does he have social? Now, let me just give you a story. There's a matter quickly. Wow, our time is almost up. I'm so sorry. There's a matter in which the judge was a defense, used to be a DPP. The prosecution filed the case, culpable homicide punishable with death, and gave a totally different venue, as a scene of crime. So the judge apparently got irritated and went on with the trial. It got to a point in convicting. In fact, while delivering judgments, he berated the counsel for the poor drafting of the charge. Berated the counsel, but went ahead, convicted the defendant for culpable homicide punishable with death. But after convicting him, the judge now suo motu amended the charge to reflect the correct venue, the place of the offense, which was not there initially. Of course, fresh plea was taken. This time, the defendant pleaded guilty, and the judge proceeded to still sentence him to death by hanging. So you see, it's such an interesting case. Of course, the Court of Appeal set aside that judgment and sent it back for retrial. Of course, well, later it was found that the judge was a DPP and he couldn't just see this thing, go by like that. So you need to know the judge and know the kind of case that the judge now would look at and how you look at it. So does he have social experiences? Is he a female judge or a male judge with lots of female children? You should know that he may not be very sympathetic in a case of rape. He may not be so sympathetic to a defendant. So you have to know how to present that case to him. What of the temperament of the judge is also there? And does he prefer oral or written addresses? So you have to look at all that. So it is very important to formulate your strategy, bearing in mind the personality of the judge. Okay, let's say this generally goes for both the prosecution and the defendant. Now, just one more instance on this so that we can close, basically. Another instance, I had a case with a learned silk, and he was just dealing with my witness. He decided his own strategy was to wear down my witness. Continued question, 2 days. And I saw my witness making mistakes. She was tired and she was just very jittery. I said, this woman will contradict herself. I quickly found a way and told them, look, my lord, I need to appeal for an adjournment because of the condition of the witness. They said, looked at me, what is her condition? I said, you can see her. Actually, the lady had a big tummy, so you may not know whether she was pregnant or not. They looked at me, looked at the lady, looked at me. Okay, no problem, granted me an adjournment. So I quickly had to go and do damage control. Now I decided to use that same strategy in another matter before another judge. This particular judge was writing down everything, but I went to another judge and used that strategy. By the second, I started cross-examining. The first day, I said, this accused person, I will deal with you. By the second day, the judge was not writing. It got to a point, said, Mrs. Eke, what are you doing? You are just, you are not going anywhere. I don't see why you are troubling this witness. Please, you have to, the questions are too many. Of course, I took an adjournment. Next time I came back with 5 questions. When I started the second question, the judge just looked at me and smiled. Say, now you are picking out the meat. Last time, it was the bones you were picking. You were picking the bones. So you see, one strategy works with one judge. It may not work with another judge. So you have to know your judge and know which strategy works. So now let's go quickly for the defense, because I think the defendant is one that we should be a bit more concerned about. So the defendant has to also formulate a strategy. I talked about somebody being ill or somebody, appearing to be vulnerable. You may want to decide to present your client, the defendant, as a vulnerable person, as an innocent person. All this is part of strategy. I had a case where a young man got away with a lot. Now, because he was always coming to court, very punctual, very well-dressed, very well-behaved. His counsel made sure he never came late to court. And I saw that the judge took a liking to the defendant. So at the end of the case, the judge convicted him of manslaughter, but adjourned the case for sentencing. I knew that it was going to be difficult for the judge to give him life, because the character, his behavior, and all in the course of the case. And the judge actually commended him for coming to court on time and always being well behaved. Well, he did not. It was a fine at the end of the day that the defendant went off with. So the strategy of the defense paid off. But there is another instance where the strategy did not pay off. That I think a lot of lawyers do it a lot of the time. It was a bail. The lawyer wanted bail for his client. So he asked the client, well, I won't say the lawyer asked the client. Now the defendant came to court looking very frail. The first time he said he was ill. The judge said, okay, we'll adjourn the case for him to get better. The next time he was still ill. So his counsel said, my lord, you need to grant him bail so he'll go and treat himself. I looked at it and said, my lord, we're here for plea. We cannot argue bail application without the defendant taking his plea. So the judge looked at us, and said, okay, rules said defense counsel, what the prosecution says is right. It's a pity your client is not well enough to take his plea from what you are saying. So he has to go back to the prisons. When he comes back, he should be better. So he can take his plea and then we can look at your bail application. Counsel asked for a moment to speak with his client defendant. They conferred briefly and the counsel came back to me. They said, my lord, I've just confirmed from the defendant that he actually feels better. The defendant actually straightened up and the judge asked him, are you well enough to take your plea now? He said, yes, my lord, I can take plea. So you see, that strategy did not work. He took his plea before we could now address the bail application. Well, I can tell you that the judge ordered accelerated hearing and did not grant bail eventually. So, I think the thing about the strategy, we all have a grasp of it. So we need to also be concerned about jurisdiction when they're talking about formulation of your strategy, raising objections, jurisdiction of the court. Are you going to, now that issue is something that's a bit thorny. It's a bit thorny. I don't know whether I'll go into the debate now, but are you going to raise objections during the trial? We already know that in criminal trials, objections are not encouraged because you are supposed to raise everything at the end of the case. But the question still remains, what if we want to raise an objection that a defense of atrefoil acquits? Should we wait to the end of the case when we have already gone through the entire case before raising that objection? What if it is on the jurisdiction of the court? So these are things that need to be examined by the defense counsel when he's preparing his strategy. And if a court rules against you, perhaps you raise an objection, the court rules against you, am I going to appeal against that ruling of the court? Or will I still wait to the end of the trial? Now, am I going to be, now for a defense counsel, you can ask, should he interject at every point when the defendant, the prosecution is called his witness, or keep silent? My advice, sometimes to keep silent pays defense more than speaking so much. So I think with that, we have basically covered most of what we need to do, the important things. And safe to say that concerning the charge, examine the charge very well. It will give the defense an opportunity to know issues to raise during the trial. So in conclusion, I'll just say that it's important to bear in mind that a criminal trial requires dedication, commitment, and attention to detail by both parties, both the prosecution and defense. Of course, the prosecution has a burden of proof. However, an indolent defense counsel who does not know when and how to take advantage of loopholes in the prosecution's case may risk having his client convicted when it could have been avoided. As they say, any person who fails to plan has already planned to fail. Thank you very much for listening to me. Thank you.
Thank you very much. It's quite obvious, Cornelia, that you planned appropriately and you've delivered maximally. So that last word of advice to us should go to the rest of us. So thank you very much for an excellent presentation. I'll come in with my comments at the end. I'll just call on some of the panelists who are available to give us their commentary on the presentation. Docs, you've been here from the beginning. Do you have anything to say?
Honestly, let me first of all, once again, say a very big thank you to Mrs. Cordelia Ike for a well-researched, delivered topic. You know, this case theory and trial plan, it's like, it was a baby of Professor Nasiru. I can see him, I think he's with us here. You know, when we're preparing the outline, he wanted us to have something there so that at least before we go into the next topic, which is trial, people would know what they're going to do during trial. And I must say that Mrs. Eke delivered it 101%, because when you prepare well, even if you don't succeed fully as a lawyer, because in our profession, they say that a loss or a win, there are no draws. The fact remains that the loss can be manageable. So I want to thank Ms. Eke for a well-delivered topic. My only addition would be that during the course of delivering the topic, Ms. Eke mentioned something about the opening statement. And of course, both for the defense and the prosecution. This is contained in most of the administration of criminal justice laws across the states. But in practice, we don't see it happening. And I think I agree with her that it's a loss to the system, because sometimes, maybe due to the fact that our judges are very busy in the kind of in number of cases they handle, it's always good to have this kind of introductory statement so that the judge can view the evidence that is being presented by both the prosecution and the defense from the light of the opening statement they made. This would help to a large extent to curb unnecessary disinterest in the kind of case either the prosecution or the defense is presenting. So I agree that maybe it's time we should encourage courts across the country to start allowing this provision that is already existing in the law to be utilized by counsel. It also helps advocacy too, and ensure that the lawyer who is defending or the lawyer who is prosecuting understands what is even bringing to court. This is very key, and I thank her for highlighting that. I also want to draw attention to the last, I think almost the last part of our presentation on whether it is even right to not make an objection in case of ultra acquit and ultra convict. I think the ACJA makes provision, and even the Constitution makes provision for a defendant to raise such objection as quickly as possible, so that he doesn't have to go through the pains and the rigors of a criminal trial before now raising it at the end of the day. Once it is clear that such a situation arises, the lawyer should be able to file an application and draw the attention of the court to the facts of he's relying on for the ultra acquit or the ultra convict, so that the court can determine that immediately and resolve it. There are provisions in the ACJA, I'm not close to it now, that says you can file such an application to insist that you are not supposed to be put through a trial. That's just what I want to add to what she said, so that we can always avail ourselves of some of these sections that prevent us from going through a criminal trial unnecessarily. Once again, my most profound gratitude to Mrs. Eke for your sterling job. Thank you very much, Chair.
Thank you very much, Docs. I can see Tola Osho, the Senior Advocate of Nigeria. Tola, you have any comments?
I don't have any comments. I just want to commend Mrs. Eke for her very well researched and presented for the well-researched presentation. I think she really broke things down and drove things home. Thank you very much, Ms. Eke.
Thank you.
Very much. Let us see Advocate of Nigeria.
Chairman, Chairman, if you don't mind,
yes.
Dr. SCN is here. During the previous presentation, he said he didn't know that he could actually, as a panelist, make his views known about some of this. I don't know if he's still here with us. I saw him here.
Victor has escaped, though. Hold on.
He has escaped. Okay.
I think so. I can't find him.
Okay. He had wanted.
Let us say, Victor, are you there?
Wanted to make a few comments on some of these things before. No problem. If he's not here, it's okay.
Yeah, I saw him earlier on, but I can't see him now. Well, we have Professor Dasri Aliyu. Prof.
Thank you, Mr. Chairman. And I must confess that although dogs always wanted to push things, it's somebody's baby, it's our baby. We worked together and then agreed. So it is the collective institute baby, right? Now, I will say that I'm a strong proponent of case theory, and I've been teaching case theory also in the university and law school again. But I must say that I'm highly impressed, and the paper, the presentation itself by Mrs. Eke I think is an excellent and wonderful one. I will tell you one of the reasons why. You know, she approached it from a practical perspective in such a way you don't need to be somebody who has to read about trial plan and case theory that to follow her. And you know, she has given you practical examples of certain things that had happened to her with her or an experience from somebody. I will say that I have written some, I think I presented paper also on this case theory at one of the MBA branches, and I've written an article published. But I will tell you that I have improved, I got an improved idea from what Mrs. Eke presented. I think by and large, the only thing that I would want to add is what I know she knows too well, even more than me, being the DPP and whatever. What have you, I mean? The issue of, you know, in trial plans, like she has rightly put it, I guess also is one of it's an important task that for a prosecutor to try to protect witnesses are part of his plans. To look, because to ensure that you protect the witness and try to see that you track the witness so that the witness will not slip out of you after you have finished your drafting and everything, and then he has been transferred. Where would he? And then it's a very difficult thing, which you have discussed it. And I think that's one other thing I want to observe. And the other thing is that, you know, there are what they call reversible challenges by a draftsman or a prosecutor. These reversible challenges are some challenges which in the course of trial plan, when you theorize the case and then you start the trial plan, and then you realize there are some frustrations which you could reverse it as a prosecutor. Thereby, let's say, while trying to have an interview with unofficial witnesses, you now realize that there is like a tangle between the unofficial witness and possibly part of the defendants, something. You may be able to call on the witness, talk to him, and let him understand that he has a duty to be not to frustrate the trial and what have you. You know, some other people may even say, okay, we'll pay for you, go for studies, so that they will frustrate the prosecution. So now those are kind of reversible challenges, which if there's a proper trial plan, just like successfully put by Ms. Eke. So I think I will say it's a wonderful presentation. Believe you me, I will improve on my articles that I wrote. Madam, thank you so much. We are really impressed.
Thank you very much, Prof. Thank you.
Well done, Prof. I mean, that commendation was very good. Okay, so
very good. I'll take it to the bank.
You should. Very cashable, that one. I'll quickly take question time. So the first person says, please, the citation of the case that just mentioned by the presenter. Thanks. Well, I'll just say that you get the slides, and I'm sure the citation will be there.
Yes.
Then please, we'll get you the slides. That's Aminu will get you the slides at the end of the session training. Can the opening statement be a similitude of a pre-trial conference in civil matters?
Okay, the opening statement, the provision, especially that of the criminal, the River State practice direction, I think that we can use that as an example. It says the opening statement should contain issues for trial. So I know one of the things that stands out the pre-trial conference is that you have to formulate your issues for determination and all. So I think that's just more or less a similarity, highlighting the issues for trial. But it is not like the pre-trial conference, because this has to be taken after plea has been taken by the defendant, on the part of the prosecution is after plea has been taken by the defendant. Then for the defense is just before the defense opens its case. In the civil matters, pre-trial conference comes before you open your case at all. So you don't wait for the defendant to open his case, for the claimant to close his case before you have pre-trial conference. So it's not exactly the same. But yes, there are some elements that are similar.
Thank you. And the next person says, please, can you share a sample or precedent of a case theory? I'm not sure how you're about to do that one, but
I think I don't know if the person was here when I was when I read out the theory, perhaps when they get the slide. There was one of the cases, Odogo and States, Vivian Odogo and States, where I tried to reproduce the case theory of the prosecution and that of the defense as presented or as summarized by the court itself. So when they get the slide, you have that, those samples are there.
Thank you. So is the attitude of not presenting opening address and theory of case more as a result of the fact that where we copied it from? I think that's what I mean. The administration of criminal adjudication is that of jury and the judge, than here that is all the work of a judge. I don't really understand. It's not very clear, but do you understand?
Okay, I think I have an idea. Whether, okay, we don't encourage it because we don't have a jury system.
Yeah, okay.
Well, yeah, the judge, I think they've partly answered the question. I don't know who posted it. The judge here sits more or less as the judge and jury. So what you would want to tell the jury, you also say the same thing to the judge. He is judging this on law and facts. But I think the main reason we don't adopt it here, or it's not encouraged, is more because of the time. The cause lists are often congested, and the courts are trying to meet up. They have their reports, their returns to give. So they want to finish with the case as quickly as possible. And of course, you can trust lawyers, trust us. A case theory, presenting an opening statement, before you know it, we are already giving the final address. Oh, yes, and I must mention that it's important for us to have an idea what our final address would even be like. Let's know the end and factor that into the beginning. What would your final address be like? What are the things you'd want to put across so that in your opening statement already, you're giving pointers to that end. So I think it's more about congested cause lists than the jury system. But of course, it may also be part of the reason why.
So last on this one, Chuga is asked whether it says, I would like to know where to draw the line between preparing a witness and tutoring a witness.
Okay. Now, preparing a witness is based on what the witness has already stated. You ask the witness, so what did you hear? Were you there on that day? What did you see? What do you know about the case? A witness can tell you a lot of things. I've had a witness that will go to town and describe the roof of the house and describe, oh, that day rain was falling, so I was already wet. And so it just goes on and on. The judge will just sit down and cross the hands and, please, can you guide your witness? I'm sure you would have heard a counsel, guide your witness. So the witness doesn't just go to town. So preparing the witness is sifting through what the witness has to say, what is important, what is not necessary. So you just get the important facts from what the witness is saying. Now, tutoring a witness is telling the witness, look, you have to say this. It doesn't matter whether it's the correct thing or not. You just want that witness to say something that may not necessarily be true, may not necessarily be the fact, it may not necessarily be what the witness saw on that day. There has been a case where a witness did not say anything. There was a case where a witness didn't say anything about about the robbers carrying a gun. Now the witness throughout said, oh, these people came to my house to rob me. They beat me up. They beat me up till I showed them where the money was. Then he gets to court. And that is also his evidence. They beat me up till I showed them where the money was. Then suddenly, somehow, a question was asked, prodding him. Were they with a gun? And he said, yes, they had a gun. So you see that that is an afterthought. It was nowhere in the statement of that witness. It was nowhere in the evidence of the witness. So the counsel was trying to tutor the witness. He must have told him before, say there is a gun. They had a gun, so that it will be armed robbery. The witness may have forgotten. So you get to court, did they have a gun? Say, yes, they had a gun. But of course, the judge saw through it and said, no, this thing, it just came up here. So that's tutoring a witness. So I hope I've been able to answer that.
Thank you very much.
The satisfaction
That was quite clear. The next one is from Udogu Chinedu. Thank you very much, Ma. Please, my question is, when the prosecution is making his opening statement, is it advisable for the defense counsel to raise objection?
No, well, it's not for the defense counsel to raise objection at that stage. I believe it should be for the courts to caution the defender, the prosecution, if it's going out of line. It's not for the defendant to raise objection, except, of course, there's a very crucial part of it. Now, an opening statement, for example, is not supposed to cast aspersions unduly or to attack perhaps the person or now to harass the defendant. In the course of making your opening statement, you, this wicked man, this stole, or, there are some words you would use in an opening statement that will be unacceptable even to the court. So when that is repeated, it is possible to draw the court's attention to it, but ordinarily, an opening statement is to the court, not to the defendant. And you could even draw the court's attention, to the use of words or language by the prosecution, but you keep your gunpowder dry because you also have the opportunity to react to what the prosecution said.
Okay, the next is an excellent lecture. I would like to ask whether an opening statement is a tool for projecting the case theory by both the prosecution and the defense.
I said that the opening statement, yes, is a way to project your case theory. You must have your story. The case theory is the theme, is the story you want to pass on. So it is through the opening statement that you pass the case theory on, that you project your case theory. This is how I see this case. And I want you to look at the case also from my perspective. That is what you're doing in the opening statement.
Interestingly, all the questions so far show that the participants have been listening attentively and they're all skewed to the paper, which is very good. But this question that I'm going to ask now the person appears not to have understood the point, but I'll let you clarify. So on knowing the judge, this is from Aisha Dele, on knowing the judge, does this not have to do with fair hearing, where the judge may have an interest in the case and so shouldn't have jurisdiction? So I'm sure she's referring to the point where talking about you must know the judge or the disposition of the judge.
Yes. Okay, knowing the judge, let me clarify. Knowing the judge is not a person having a personal relationship with the judge or is somebody, but knowing the judge, what I mean is the judge's disposition to issues, the judge's disposition, the judge's temperament, what the judge, his antecedents. You will know there are judges in our jurisdictions, there are judges say, if you go to this court, armed robbery, you are going for it. Or another one, courtesim, this judge has been kidnapped before. So kidnappers going to that court, you might have a problem. Not that you have a problem, but the thing is, the judge is not likely to smile. So you have to have a very good defense when you're going, if your case is in that court. So issue of fair hearing, well, it's easy to know when an issue of fair hearing has been breached. If you have facts, you can't just say there was no fair hearing. You have to have facts to support that kind of assertion. In what way has your right to fair hearing or the defendant's right to fair hearing been breached? Perhaps if it's the defendant's brother, is it the defendant's brother that kidnapped the judge before that day? then you can say, oh, because that's what happened, the judge will not give the defendant fair hearing. But basically knowing the judge has to do with his temperament and probably antecedents in other cases. I know a judge, for one, I know a judge that is very reluctant to send people to to convict for manslaughter. Well, he convicts, right? He will convict, but he's very reluctant to send you to prison. He would prefer giving a fine instead of life imprisonment. I haven't heard him, any matter where he gave life imprisonment. He would rather prescribe, okay, penalty, a fine or so. So when I have a matter in this court, I'll say, oh, this one, I know it is, the most you get, the term of years. And fine, the term of years, and then fine in lieu. That, so ahead of time. So sometimes what some lawyers do, when they know the judge, they know the antecedents of the judge, they withdraw the case and refile. Somebody told one of my colleagues recently, some time ago, that, look, I don't want this case before a judge from this tribe, because that tribe, they have this particular disposition. So when he filed the case and the case was sent to a judge from that tribe, he quickly called my colleague, said, please, you need to withdraw this one. Find another information. It's almost like forum shopping, but say, please file another information. I know the disposition of people from this tribe, and this case will go nowhere.
That one is on the extreme.
I hope that has helped.
Was a very interesting point, to classify an entire group of people and then decide that is their disposition. But I think that part of the reason why the lecture is actually interesting is it brings a practical perspective to things. You're talking from experience, and I think that's what the participants should take away, because I don't think that they'll teach you this kind of thing in law school, but practitioners, everybody knows what you see, and then that's the guidance that you get. So thank you very much for that. Is it wiser to object to admissibility of a document before it is admitted in evidence, or should a lawyer wait and raise the objection during final address?
Well, there is a context now. I don't know if it's a civil or in criminal. If it's criminal we're talking about, when the document is tendered, of course, it will be presented. Let's say, is it the defendants, the prosecutions, is it that the statements, extrajudicial statements, or you have perhaps the medical reports. The courts usually, when the prosecution is tendering the document, they would ask the defense counsel, do you have any objections to this document being admitted? So of course, at that point, you're entitled to raise your objection if you have an objection to it, and give reasons why. But if the court says, okay, fine, I will admit it anyway, and rule on it at the end of the case, which happens in a lot of cases also, that is also permissible.
So Oluwaseun Adeogu says, thank you, Ms. Seke, for a well-delivered presentation. Can the issue of jurisdiction be raised at the point of criminal trial? Not clear. Not even at any point in criminal trial, I'm not sure.
Yeah, the issue of the jurisdiction, whether it can be raised. Of course, the issue of jurisdiction can be raised even on appeal. The issue of jurisdiction can be raised even on appeal. Now, there are cases where you have in fact, I think this has something to do with section, is it 398? Also, which is still causing a bit of a controversy, which seems to be quite ambitious. Well, at least some persons feel it's quite ambitious. I know Prof talked about it yesterday. I believe Prof talked about section 398 or so yesterday on the issue of raising objections and waiting to the end of the trial. Now, there are instances where a case should not be tried in a particular court. So that's a practicality of the situation now. You have a federal offense, it's being tried in the wrong court. Of course, the court does not have jurisdiction. Or you look at the charge when you look at the charges, from the charges alone, you know that the court does not have jurisdiction. So 398, I think I had that here with me. The ACJ check. I think it seems to propose that all the objections be taken, argued at the end of the case. However, if you do not take jurisdiction, issues of jurisdiction, 398, early enough, it means the person will go through the whole trial without, in fact, you just suffer the whole trial for nothing. If the case is in the wrong court and you have to wait till the end of the trial, then it's a problem. So you have to, the issue of jurisdiction has to be taken. That is still my view, has to be taken as early as possible in the, sorry, it's not 398. I need to get this. I mean, I've got it wrong. Trying to get, okay. But then the issue of jurisdiction should be raised, in my view, as early as possible in the case. And then the court will decide whether to determine it at that point. Sometimes the courts tell you, I will rule on it with my judgment. And from experience, there's a judge that a judge that mentioned that, look, by the time I say I'll rule on it with my judgments, it should already give you an indication that it's likely not to succeed, because I now have to do all the work. You know, I'll hear the trial and everything before still saying, no, I don't have jurisdiction. But it can be raised and then argued during your final address. But you can file, I believe you can file your preliminary objection, issue of jurisdiction, and then argue it at the end of the case.
Okay, thank you. The next person is saying, please, ma'am, I want an explanation of the strategies to be employed by the prosecution. This is from Lara Ibrahim.
Sorry, can you just take that again? I didn't hear it so clearly.
So Lara Ibrahim wants to know, have an explanation of the strategies to be employed by the prosecution.
Okay, the strategies to be employed by the prosecution. Okay. Let me see. Okay. Okay, yes. He wants to know the strategy that should be employed by the prosecution. Is it a particular case? I think there's still a part of that question I missed. I apologize. I think
no.
There's
Just
something
simple and straight. Just say strategies to be employed by the prosecution.
By the prosecution. Well, a prosecution, you seek to present a case to the court. Now, how do I get the court to, how do I present this case? Am I going to field all my witnesses? Is it by the number of witnesses? Or I just concentrate on getting in particular documents? Now, I can tell you from experience, there are times we have problems getting doctors, medical doctors, to come to testify. In fact, I've lost a case because the Medicine Sans Frontiers, that's actually the one particular organization that provided services for rape victims and all, they temporarily left town. So the doctors were not available. Now, they had attended to this young lady when she was raped. But I needed a doctor to come to court to testify. At that time, they were no longer in town. They were not operating. I couldn't get the doctor to testify. Now, I had made the mistake of not tendering the doctor's report through the IPO. If I had taking this fact into consideration, in fact, if I had looked for, that's the thing about planning your case. Okay, you have the witnesses, are they all available? If I had paid attention to that fact at the planning stage, I would have realized that, oh, these people are no longer in town. And it may not be possible to get the doctors to testify. So what would I have done? I could tender it through the IPO. This is part of what they recovered in the course of the investigation. So it is before the court. Let the court decide what weight to attach to it. But I didn't tender that medical report through the doctor, through the IPO. I was looking for the doctor. There was no doctor to testify concerning the rape. So when it got to me later, after several adjournments, I said, I have to go back to recall the IPO. He was no longer within jurisdiction. And it was going to cost me a lot to bring him down. I was willing to try, but the father of the young lady was already tired of the case and he wasn't ready to fund it because you have to pay the transport fare of the IPO to come from wherever he was. After several adjournments, we were foreclosed. So if I had planned, if I'd had my strategy, put it in, just put in all the documents. There's even another one I have, say, put in all your documents. Let the court decide which one it will use. You never know which one will be useful. So that's part of the strategy. How many witnesses, who is credible, who is not credible. In fact, what we'll do, we're just going to give the court enough work. And another thing, see this defendant, we are going to harass him until he tells the truth. But there's another strategy you can use. You can decide to be nice. I do that sometimes. Decide to be nice. The point is, get the defendant to give you as many yeses as possible in cross-examination. So you can just be nice and get him to relax. So you're asking questions that are familiar to him. Questions that appear as though you're even praising him. And he's comfortable, he gets relaxed. So when you ask the main questions, he's already in that relaxed mode and he gives you the answer without thinking of what he has been too taught to say. So that's part of your strategy. You can decide to be nice and later you can decide to be hard. So, all that is something you formulate with time. Different things work for different lawyers.
So, Oludayeni, can a defense counsel, as a matter of strategy, utilize the no-case submission application, and if it fails, instead of entering defense as reasonably expected, decides to rest the case of the defense on that of the prosecution?
Yes. Yes, no case submission is part of the strategy that defense can use. And sometimes, now let me tell you what happens in some cases. The defense counsel can look at the case and say, look, this is a bad case. If this case goes to full trial, my client is going in for it. So the defense counsel can decide to look for all ways possible, is a strategy to terminate the case before it goes to full trial. So he keeps looking for things, picking holes here. That's where you talk about objections and motions and all. He just wants to terminate the case. If you're not gay, I'll have the case terminated. Now, sometimes what the defense counsel wants is to delay the case. The defendant may even know, he will say, look, just get me out on bail. So long as I'm coming from the house, I'm okay. I have a case right now that the defense is stalling the case. I know they are stalling the case. We have a lot of witnesses, the evidence. Remember, there are two cases. I don't want to give the details because it will just be obvious to these people. They are stalling the case. And you know what they're doing? They have brought an application for plea bargain. I tell you the plea bargain, okay, no, they informed the court they want to plea bargain. But it has taken, for the past 6 months, they haven't even brought a formal application for plea bargain. But any day we go to court, oh, plea bargain. My lord, we cannot proceed, plea bargain. So they just bandied that word. All they want is to delay the case. And in some cases, what the defendants want, let me just say it out here. So we're talking practical things. Sometimes a defense counsel is looking for how to get the defendant out on jail delivery, goal delivery exercise. So in delaying the case, so okay, you find a way, you just want to try luck, whether they will release him during goal delivery exercise. So for some defendants, that's a strategy. So there are different kinds of strategy that they employ, but also I've also mentioned that, you know, some may just say, look, the man is sick, he's sick, he's sick, and the judge will just, out of pity or even use the age, decide to grant, expedite the trial, you know, fast track the trial, or grant some concession to the defense. So no case submission is good. If it fails, then you continue with the case. Now, resting your case on that of the prosecution, I must address that. You have to be very careful. A defense counsel decided to do that, rest his case on my case, the case of the prosecution, the case I was prosecuting. And I asked myself, is it that we have not done anything at all in this case for him to be so confident as to rest his case on that of the prosecution? The court asked him, are you sure? Are you sure? Asked like 3 times. The counsel said, yes, I'm sure. But he should have taken the hint of the court. Asking that question, the court knew why there was something. It is risky to rest your case on that of prosecution, because it means you have admitted everything the prosecution has said. Now, when you rest your case on prosecution, find out, before you do that, find out what it entails. Are you still entitled to right to address? Are you still entitled to do anything else in the course of trial? Can you change your mind and say, okay, I'm no longer, you know, so those are things. So please, rest in case of that prosecution, let it be only when, you know, if you are absolutely sure that you must do that. Of course, another strategy, you know, you can decide that the defendant won't testify, because your defendant may not be reliable. He may come and you're not sure he's going to give you what you want. He may just go and spoil his own case. So you prefer not to put him in the box. You know, field other witnesses, but the defendant can decide not to speak. And he cannot be compelled to testify. Thank you.
Thank you. How does the defense counsel, this is Adeyinka Akonji, how does the defense counsel handle a situation where the IPO is transferred and other officers are not conversant with the case or are reluctant to take it over?
A case, well, how does a defense counsel, or it should be a prosecuting counsel, I believe? Is it prosecution or defense?
Defense was what he said. How does the defense counsel handle a situation where the IPO is transferred and other officers are not conversant with the case or are reluctant to take it over?
Well, it shouldn't be the problem of the defense. It's actually the problem of prosecution. The prosecution needs the IPO to tender the extrajudicial statement of the accused to show that there was an investigation, there was fair hearing. If the IPO is not there, then you have a bit of a problem. I have also lost a case because of that. And that was because all the witnesses, everybody had testified, IPO was not there. And I got to find out later that the IPO had been compromised. And he was the only person available that investigated that case from where it emanated. It wasn't a team. So that destroyed my case. So that is a concern of the prosecution. Now, so for the prosecution, if you have such a case, I even have, there's another one, an IPO is there, but he's being difficult. He says, oh, I'm not the one that investigated this part. It's the other person. And the main IPO is late. So he's not even talking about bringing from anywhere. His team member does not seem to know much about the matter. So you can subpoena a superior officer that somebody must have assigned the case to the IPO. So there must be something official, an official of the police that can tender the documents you want. So it will now be up to the court to determine what weight to be attached to it because of the person that is coming. He may not have direct knowledge of how the document was obtained. So that's for the prosecution. But for the defendants, you don't need to trouble yourself because it helps you. It helps create reasonable doubt. Okay, thank you. Sorry, Tobena, you're muted.
Yeah, good afternoon, learned seniors. I wish to get your opinions on judges requesting that prosecution file witness depositions on oath.
Well, in criminal matters, filing witness deposition on oath is something that it's been regarded with mixed, is generating mixed reactions, really. And I'll tell you, frankly, speaking candidly, for the prosecution witnesses, I just feel that it is a surplusage. We are talking about speedy trials, speedy dispensation of justice. Does it really speed up the trial? That, I believe, may be part of the reason why judges, I think by practice directions, insisting that witness deposition be filed. But the peculiarity of a criminal trial, it's different from that of the civil. Everything is important. Observing the demeanor of the witness is important. And you really would not want to have a situation to give room for appeal over a particular aspect of the trial. Now, for the defense, I'm particularly wondering how the defendant in custody will have to depose to an affidavit. That is witness depositions. He already has a statement, which he may deny or accept. But the issue of filing witness depositions on both sides, while it is seen as something that will speed up trial, I am also concerned that it may not meet the integrity of the process or a criminal trial. So some judges, of course, go with it. They allow it, yes, go ahead and file. I'm waiting for appeals. I think it's also new in some jurisdictions. I know we have that in the practice direction in Rivers State now. So I'm waiting for it to be tested on appeal. Can we really do that in a criminal trial? Personally, I do not think it's ideal.
Thank you. The last question is from Oche Abutu. Says, how do you manage the overindulgence of the Senior Advocate of Nigeria by judges and the restrictions that prosecutors, especially junior ones, suffer in criminal trial? It impacts on delivering your strategy.
Well, being a senior advocate comes with privileges, and the indulgence is part of the privilege that is given to a senior advocate. So we would all respect that. However, it pays to bear in mind that it is not in the length of speeches, nor the elaborate nature of the argument of any party that you win the case. A particular party counsel maybe is very elaborate and go to town, take a day or two in addressing a particular issue. But at the end of the day, it is the substance of what is being said that is important. And I advise young counsel to prepare well. Nobody can argue with facts. Nobody can argue with the law. If you are well prepared, you just wait and bid your time. At the appropriate time, you also have, the court cannot deny you your right. Now you have there are provisions for adumbration. So if you feel you're being shut out, you can draw the court's attention to the fact that you have a right to adumbrate. If you have your 10 minutes, if you have 15 minutes, depending on the particular case, the particular application, you have a right to adumbrate. So unless the court makes a ruling abridging the time, and I don't think the court will do that for only one party, it will have to be for both parties. So concentrate on your own part of the work and get it done. So just ask for what belongs to you, the rights, that the time that belongs to you, and make good use of it.
Thank you. Ishak Abdullahi said, I want to know the essence of traces of evidence in a charge.
The essence of what?
Traces of evidence in a charge.
Traces of evidence.
Traces.
Sorry, I seem to
Traces of evidence. Okay. I'll come back on that one. So says,
I think he means a summary, an extract.
Yeah.
The press is
of evidence.
Yeah, summary or extract of evidence, yes.
Okay, in the charge.
Oh,
now,
traces of evidence, that's summary of evidence.
Okay, pressy.
Yes, presses.
Okay, I understand now. Yeah, sorry. Of evidence in the charge. Well, I have seen some charges that are a bit unwieldy. Some prosecutors go to town, putting in the charge sheet, in the charge, a lot of things that are unnecessary. You know, it makes the charge unwieldy. And some of them go to no issue. We just need to keep in mind, what should a charge contain? Where the place of the offense, place was committed, who committed the offense. You know, you need the time, the dates, have the salient information. You don't need to make an elaborate statement or a long paragraph. It can actually distract attention from the main ingredients of that charge. So it is not necessary. It doesn't add any value to your charge. You will not make the judge look at it as, oh, this is a serious charge or not, because the judge doesn't even want to waste time, you know, pick the main issues. You still have a proof of evidence, you know, that shows what you are trying to project to the court. So you don't need a lengthy charge, an unwieldy charge. That's not where you present the evidence. Thanks.
Shimo Lawan says, good afternoon, learned seniors, as well as colleagues. I asked several questions. You did not take our question. What happened? Hashimo, please, can you send it to the Q&A box right here, because we haven't seen any of your questions. If we do, we'll ask it, but time, we're running out of time anyway, but do quickly. The next person says, good day, sir. Please, I'm kindly, oh no, that's for slides. You will get the slides at the end of the series. Mashika Paul Shimon, how can one prepare for a witness under subpoena who is not your witness?
Okay, if the other party is one that subpoenaed the witness, well, you'll be given notice that such a witness is going to be called. So that's the first thing. They won't just subpoena the witness without letting you know that if the prosecution wants to subpoena a witness, it has to be part of the list of witnesses. So you're on notice that such a witness is going to be subpoenaed. And of course, you have the right to cross-examine whatever witness is subpoenaed by the prosecution. So same goes for the defense. As it is now, the defense is required to also furnish the prosecution with a list of the witnesses it intends to call. The prosecution is entitled to demand that, so you prepare accordingly. Now, you may not be able to know everything that witness is going to say. Of course, you won't, because it's not your witness. But you're entitled to, in certain cases, you're entitled to either seek an adjournment or seek a stand down if these are material issues. But you can even preempt. If it says I'm bringing in a medical practitioner from here, or it's bringing a ballistician, you should prepare yourself. I've had a ballistician in the box and it was subpoenaed. So his evidence was not given to the defense beforehand, but the defense was prepared and they knew the questions to ask. As a ballistician, did you get the bullets? What and what did you examine? So you just go and read up and ask questions. What ordinarily is expected of these experts in this area? Then you prepare for it. So it may not take you so much, but if there's a reason why you need an adjournment, for that, then of course you have to convince the court.
What do you do in the middle of the trial when the trial takes a sharp turn after you have mapped out your case theory? How can you swing the pendulum at that point?
Sorry, please, just take it again.
So it says, what do you do in the middle of a trial when the trial takes a sharp turn after you have mapped out your case theory? How can you swing the pendulum at that point?
Well, it happens when it can happen if you suddenly find out that your witness or maybe the information we're given is not entirely correct. You know, there are different scenarios that could just seem to put all your plans in disarray and the theory you had actually formulated. But that's why we're lawyers. You have to be quick-witted. You have to be quick-witted. So from the beginning, in fact, you can just create an alternative and you try not to box yourself into a corner in your case theory. Like for the defense, you may not say so much. You don't give out so much. Give a bit of room when you are formulating case theory. What if, in the case this happens, you should have a plan B? You may not be able to cover all the scenarios, but you have to think on your feet as a lawyer and quickly know how to navigate. So you can't have everything 100% at the beginning of the case. Surprises still do come up. Even your witness can spring a surprise on you. During cross-examination, you'll be asked a question and you'll be shocked too at the answer your witness would give. Say, but you never told me this. But maybe re-examination, well, even if he said this, it does not mean that this is the other, that is still goes to prove the points you are trying to make this court believe. You can find a way out and say, well, it goes to no issue. So just keep your eyes on the ball and know what materially affects your case and what does not materially affect your case. So don't chase shadows and don't beat yourself about what is beyond your control. You can only do your job as a lawyer. You know, you are not the judge. The judge will take the decision. So long as you're satisfied yourself, you've done the best you can based on the facts you were given, then I think you don't need to worry.
We have about 5 minutes to go. We'll take about 3 questions more. Wale, please try and capture all the questions so we can have them answered offline. So the next question is, how can I apply today's presentation to court martials under the armed forces? Adetola Oduole.
Then how can he what?
How can he apply today's presentation to court martials under the armed forces?
How can he apply?
Yes.
Okay, is it the case planning or case theory?
Case theory, yes, the entire lecture, yes. Can he
yes,
apply
so
it?
court martial.
Yes.
Well, every case you have must have a plan. You have a court martial proceedings. What are the facts? What do you intend to do? So in fact, the essence of this whole lecture, this whole discussion is how do you approach the case? What is the plan? What is the picture you want to present before the court martial? You want to claim, yeah, their rights. Or the defendant, yes, he did this. Do you have a defense? Now, if it's a defense counsel, do you have a defense? Yes. He killed somebody, but not intentionally, to reduce it to manslaughter. Or do you want to say, no, I never did it at all. He never did it at all. It's also part of your case theory and your plan. We've had an instance where, somebody is saying, I didn't do this. I wasn't there. I didn't kill him. Then later on, he said, oh, it was not, then he was using the defense of, he has a defense Was it the defense? I'm trying to remember. Thereafter, in that he used another defense, which presupposes that you must have admitted doing it before you say, oh, it was provocation. I think it's defense of provocation. Say, if in the alternative, we plead the defense of provocation. I said, no, it cannot be an alternative. It's either you admit, first of all, yes, defendant did this. It was his action that caused the death. But it did that because it was highly provoked. Then it can come in. So in whatever case you're handling, you need to have a theory, you need to have a plan, you need to have a strategy. Are you trying to reduce the charge, the sentence for your clients, or are you trying to get him off completely? What is your plan? Thank you. Sorry, Chair, I think you're muted again.
Okay, back on. Thank you. I think now it's time now to sign off. 2 o'clock. I mean, it's 2 o'clock, so it's time to sign off. Thank you very much, Mrs. Eke, for a very brilliant presentation. I think you even did more with the questions and the presentation, but it showed how interactive and how engaging the presentation itself was, that the participants had so many questions to ask, and indeed ask questions directly related to the presentation. It was very clear, very lucid, very interesting, very illuminating, and very practical. And I'm sure that we've all picked 1 or 2 lessons from this in planning ourselves and managing ourselves, even outside litigation. So thank you very much. Thank you very much for a brilliant presentation. God bless you.
Thank you for having me.
Thank you.
Thank you very much.
Yeah, so the next, we'll continue again on Thursday. Look out for the flyers just to know what exactly we're going to be doing on Thursday. And every Thursday at 2 p.m., Friday at 3 p.m., and Saturday noon to 2 p.m. And it was quite impressive to see the number of people that left all they were doing today to join in today.
On a Saturday, right?
Yes, and they stayed on throughout. So thank you very much. Congratulations to the team. Docs, thank you for staying throughout.
Congratulations.
Sarah, Wale,
yes.
Everybody, goodbye and see you soon. God bless you all.
God bless you too. Thank you for putting it together.
Thank you. Very good comments coming through. I'm just reading them. Very brilliant. Everybody seems to be very happy.
I'm glad.
Yeah, very good.
Okay.
All smiles.
I'm seeing the comments too, and it's nice to see that people could relate to the topic.
Yes. Good investment in people. So fantastic.
Yes. Fantastic. I guess it is one of the best programs the NBA has embarked on for some time. And seeing people actually sit down and burn their data, stay an hour, 2 hours consistently listening to these training sessions is very encouraging. It's really amazing.
Indeed. I mean, yesterday we did about 4,500 people, which is quite a number by any stretch. So brilliant.
Wow.
And we're thankful.
Wow. That's wonderful. Thank you. Great team. Great job.
Thank you.
People have been amazing. Amazing. Thank you, Mr. Chair.
I'm sure the Port Harcourt people are very happy today.
Well, I should think so. That's how we put to join. I should think so. I hope I represented them well.
No, you represented excellently. The problem with MBA is that everything is, if you like, people are so territorial and political. So we haven't seen anybody from our branch here. What's going on? So when we have people from different branches,
it's good to have a spread.
Yes, it is good.
It's good to have a spread, and your committee has done well.
Yeah. The difficulty you have sometimes is when you have certain topics that you struggle to find people in different locations for. So you're doing finance or oil and gas.
So
there are not too many places.
You said the slides will be available.
Yes, no, the slides will be available. Yes. We always
Okay.
compile them. And someone just suggested that we do a compendium slide. So I think that's a good idea. So there's an e-copy that binds everything that we've done together, circulates. I think we'll take that up.
Okay.
Yeah.
Okay. I didn't even mention some of the things I'd even discussed. It could be found in my book, you know, but it's okay. Those that
I hope that people are
have
still listening. Can you give them the name of the book? There's still some people on.
okay. I have a book, that's the book.
Yeah.
As Criminal Justice in Nigeria, a practical guide.
Yes.
So some of the things discussed, some I couldn't actually say so much about because of time, but you can find some of that in the book. Those that are able to get a copy of the book. It's also online, and of course, can always reach me. It's in different places, Lagos, Abuja, no. But if you need, you can always reach me or reach the organizers. So you get to know more. It's about practice, really. When you've practiced for 20 years plus, you have a lot you also want to pass on. Thank you very much.
Yeah, when we circulate the slides, we'll also mention the book there and other books
Okay.
by those who have other tutors.
Yes, as speakers, yes.
Thank you.
Okay.
Well, are you not going to
Chairman.
shut down the system today? You want us to remain on? You want me to shut it down? Wale must have
Are you sure Wale is with us?
Wale is gone.
Okay.
Okay.
So
Anyway.
unless you're going to serve us lunch online, I think you can release us.
I would love to do that. I would love to do that. I think I can shut down from here, but no, it's just me leaving. Sarah, are you there? No. Sarah? Wale? Okay, let's see.
Thank you. You should be the host now, so you can shut it down.
I've seen someone that tells me to leave, but I don't think he's made me host. So it would be polite to me whilst everyone is still here. I'll call him.
Okay, yes.